Hey everybody, welcome to Lawyer Live with Matt the Lawyer. I am Matt the Lawyer, Matt Johnston. So before we get started, I do want to remind everybody to go check out the rest of our website, particularly the blog. Also, you can download my book on contracts, how you can work with contracts to make your contract your way, to make it more effective for you and your customers. So today is going to be a little bit of a longer video, I think. I think it's a function of the importance of what I'm about to discuss, but also some changes, I think, in the way the law is going to be approached as it applies to sexual harassment. A couple of weeks ago, the Third Circuit Court of Appeals, which is based up in Philadelphia but encompasses Pennsylvania, New Jersey, and some other areas, issued an opinion called Minarski versus Susquehanna County. Now, if you look at the facts of this case, it's a sexual harassment case. The facts of the case are pretty extreme, sounds pretty bad. And they involve a supervisor who made a long series of unwanted sexual advances against a subordinate employee. The advances and the activity were borderline rape, in my opinion, but certainly well over the line. Part of the facts involved here is that the woman, who was a part-time secretary, needed the job, needed the county job, the county health benefits, because she had a child with cancer. Over the course of 4 years, this activity continued, and she didn't report it. Finally, it got reported. The supervisor was ultimately fired, and Ms. Minarski decided to go ahead and file suit, a sexual harassment suit. The Susquehanna County, the county, countered with what is particularly common in sexual harassment suits. It's called the Farragher-Ellerth defense. Basically, it's an affirmative defense that says something along these lines. This is the sort of the legal quote of it. It says that an employer The employer must show that an employer exercised reasonable care to prevent and correct promptly any sexual harassing behavior, and B, that the plaintiff employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to avoid harm otherwise. That's a lot of legalese, but essentially what the defense means is that if the employer takes prompt corrective action and has a reporting mechanism by which an employee can report harassing behavior, then generally the employer is held not to be liable for the sexual harassing conduct. Here's the problem, though. The problem is, of course, that there's an awful lot of people who, for whatever reason, many of it mental state, many of it a function of not feeling like that policy is going to protect them, a lot of harassment doesn't get reported. Now, while the circumstances of this case were pretty extreme, the Third Circuit Court of Appeals took an opportunity to really address this sort of notion of unreasonableness. See, in the rest of the legal world, facts like these would get to a jury. A jury would be able to determine what was reasonable and what was not. But the Farragher-Ellerth defense has sort of avoided a lot of these jury trials. But the big news out of this is something called footnote 12, or it's becoming known as footnote 12. And I'm going to take the unusual step of actually reading this footnote, because this is the first time, I think, as far as I've been able to find, that the concepts of the Me Too movement have directly impacted what is happening in the courts. And this is a big step forward. So here is what the majority opinion wrote in, or what the opinion of the court wrote in footnote 12, and I quote, "This appeal comes to us in the midst of a national news regarding a veritable firestorm of allegations of rampant sexual misconduct that has been closeted for years, not reported by the victims. It has come to light years later that people in positions of power and celebrity have exploited their authority to make unwanted sexual advances. In many such instances, the harasser wielded control over the harassed individual's employment or work environment. In nearly all of the instances, the victims asserted a plausible fear of serious adverse consequences had they spoken up at the time the conduct occurred. While the policy underlying Farragher-Ellers places the onus on the harassed employee to report her harasser and would fault her for not calling out this conduct so as to prevent it, a jury could conclude that the employee's non-reporting was understandable, perhaps even reasonable. That is, there may be a certain fallacy that underlies the notion that reporting sexual misconduct will end it. Victims do not always view it in this way. Instead, they anticipate negative consequences or fear that the harassers will face no reprimand. Thus, more often than not, victims choose not to report the harassment. Recent news articles report that studies have shown that not only is sex-based harassment in the workplace pervasive, but also the failure to report is widespread. Nearly 1/3 of American women have experienced unwanted sexual advances from male coworkers, and nearly 1/4 of American women have experienced such advances from men who had influence over the conditions of their employment, according to an ABC News Washington Post poll from October 2017. Most of all, the women who experienced harassment report that the male harassers faced no consequences. And there's a cite to a news article. Continuing, additionally, 3 out of 4 women who have been harassed failed to report it. A 2016 Equal Opportunity Employment Commission Select Task Force study found that approximately 75% of those who experienced harassment never reported it or filed a complaint, but instead would avoid the harasser, deny or downplay the gravity of the situation, or attempt to ignore, forget, or endure the behavior. Again, there's another citation to the report. Those employees who faced harassing behaviors did not report this experience, quote, because they feared disbelief of their claim, inaction on their claim, blame, social or professional retaliation. Again, another citation that asserted that women do not report harassment because of retaliation fears, the bystander effect, and male-dominated work environments. That's what the court said in a footnote. Now, here's the real impact of things. The Me Too movement is really starting to impact the way courts are going to start looking at sexual harassment cases. They are now going to, instead of passing out summary judgment based upon that Ellers defense, they are going to start kicking these things to the jury and letting the jury decide these things. So for employers who get sued for a sexual harassment case, the big issue right now is that you're not going to be able to rely simply upon a posted employee handbook policy that says we don't tolerate sexual harassment and we have this reporting procedure. They're going to start looking a little bit more closer at what were the actual circumstances. So it's not going to be enough to have this cursory review of the employee handbook and an assertion that the employee was unreasonable in reporting it. Courts are going to start kicking this thing to the jury and letting the jury decide whether or not it's unreasonable. So here's my advice to employers. Number one, consult your attorney, sit down, let's talk about what your current sexual harassment policy is, and let's really start talking about active, regular, upfront training so that A, employees understand both what is harassment and that there is going to be consequences if harassing behavior is reported and found to be accurate. Number two, we can no longer ignore the social movement if you're an employer, and we do have to start taking care to make sure that employees are free from harassment. Now, let's be clear, workplace harassment doesn't just involve what's happening at your office. It can happen to if an employee is out of the office, on work business, if your customers are harassing people, if your work partners, your contractors, your subcontractors are harassing your staff. As an employer, it is your responsibility to put an end to that. It is your responsibility to investigate it, and it's your responsibility to ensure that your employees are not subject to sexual harassment. One of the longer term effects of this case might be that these kinds of sexual harassment defenses And let's be clear, the Farragher-Ellerth defense is to any sort of discrimination, but it's typically been applied to sexual harassment cases. But it could apply to any other case. And remember, the big five at the federal level is sex, race, color, national origin, and religion. So any of those sorts of discrimination cases are subject to this Farragher-Ellerth defense, but also are probably going to be impacted by this case coming out of the Third Circuit. This is not law all over the country yet, but I do think it will be. I think cases that are coming up before the courts now are going to be citing this case, and in particular footnote 12, to start making the defense that this is something that should be decided by a jury. So for employers, you need to start taking these kinds of things seriously, because you are now facing the likelihood of a jury trial, which is far more expensive than a summary judgment case. I know that's a little bit technical. I hope if anybody has any questions, please give me a call. We can talk a little bit further about this. This is a longer video, but I think it's important enough that it warrants the longer video. For now, I'm Matt the Lawyer, signing off. Go out and watch some live soccer.